a recent Illinois undue influence case, one sibling against another sibling, and the issue of checks that were written by mom before she passed away. Hello, my name is John P.L.C. I'm an estate and inheritance litigation attorney in West Palm Beach, Florida. I practice with the P.L.C. Hauser law firm, where we restrict our practice to trials, disputes, and appeals involving wills, trusts, estates, guardianships, and related real estate and commercial and business litigation. Our practice is throughout Florida, but now I want to speak to you about a non-Florida case. This is an Illinois case that was just handed down October 25th, 2016. If you've ever been involved in a case where gifts are made right before mom died, or maybe when mom or dad was incapacitated or incompetent, or maybe not there yet, but getting there, you know that there's a lot of probate litigation over those lifetime gifts, those pre-death gifts, and sometimes they're in the form of checks, sometimes they're in the form of ATM withdrawals. Well, here's a recent Illinois case that if you're involved in a situation like that, you might want to read. This is the guardianship of Spinney, S-P-I-N-N-I-E, versus Gooch, G-O-O-C-H. It's an unpublished opinion. The site is 2016 IL Illinois Appeal, APP. It's out of the 5th, 150564-U. This is an appeal from the Circuit Court in St. Clair County. And this was a case where one brother, who was the guardian, was accusing a sister who had the power of attorney of receiving gifts improperly. There was testimony that Agnes, the mom, had made a number of gifts by check to family members, including to the power of attorney. So in this case, what we see is a brother questioning the power of attorney, the attorney in fact, being the benefit of some of those gifts. Why? Well, here in Florida, we know that a presumption of undue influence can arise if you're in a confidential relationship with somebody, like a power of attorney, like an attorney in fact, and you're the recipient of a gift, you're the beneficiary of a gift. That raises questions, and the evidentiary and procedural burden can shift to the attorney in fact. The burden can shift to the person who's the recipient of the gift, and then they have to rebut that in a trial. So you can read all about this case and the checks that were written and the ruling that the Illinois court gave. But it also defined undue influence. Why do we care about undue influence? We see allegations of undue influence quite often in Florida probate litigation lawsuits. And this is interesting because we get to see how Illinois defines undue influence. Undue influence is defined as any improper urgency of persuasion whereby the will of a person is overpowered and he is induced to do or forbear an act which he would not do or would not do if left to act freely. My name is John P.L.C. This concludes my remarks about this power of attorney lawsuit and this guardianship lawsuit from Illinois.